Hey, come on in. I'm going to wait for you guys to tune in. If this is your first time, definitely comment. Let me know where you're tuning in from. Morning. Hi, Instagram. Hi, YouTube. Hi, Facebook. Where is everyone tuning in from? Let me know if it's your first time. Good morning, Tindri. Good morning, Lily, V's, Barbie Shay. Good morning. Good morning, Shaddy's Boo. Grand Rising from Portland. Good morning from DFW, Texas. Good morning, Cleopatra on YouTube and Africana Shege in New York on YouTube. Barbie Shay, your first time and you're from Jamaica but in the US. Welcome. What's a guan? Good morning. Thank you for tuning in. Nadia says, hi, should you accept clients in the DMV area? Yes, we accept clients all over the United States. We're an immigration law firm, so it means that we have clients in basically all 50 states, so your location is not a problem. I personally went to law school in the DMV area, so I lived there for a few years, one of my favorite places. Good morning, Tin from Florida. EJ from Maryland, good morning. The I-130 applications taken longer. Not necessarily. It only depends on what your preference is. But for most immediate relative type cases, the timeline is still the same. So it's only if, you're in a priority preference category, then you might see a longer timeline just because, the preferences have moved a little bit. So those are taking longer, but the typical ones should be fine. Good morning, McLean from New Jersey and Kim Buck from Oregon. Good morning, guys. I woke up so early today because USCIS decided to schedule my client for an interview at 7 a.m. And that interview was not meant to be scheduled because it was a client who had a valid abeyance case. But, always want to go in the abundance of caution. And of course, we go there after driving that far there. And, the officer says, oh, yeah, sorry, guys, we shouldn't have scheduled you. And I was like, yeah. Hopefully this is the last time you schedule us mistakenly again. But anyway, good morning, Salma from New York. I have a good topic for you guys today, but let me introduce myself, especially for the first timers. My name is Aisha Chidole, and I'm an immigration lawyer. I present clients in all 50 states with the immigration matters. We handle humanitarian-based cases, so very complex VAWA cases, T visa cases, U visa, some removal work, with masters, 42B cancellations. We also handle, family-based immigration. So if you want to file for your parent, your spouse, your children, we help you with that. As a matter of fact, I'm going to be posting a testimony of one of our clients who got a really good results today, which kind of inspired me to talk about this topic. But before I get started, let me just give you guys my phone number. It's 407-995-6567. You can also send a WhatsApp to 404-333-8751. Once I get off here, my number is in my profile right there. And you can also see it through the ticket that's scrolling through on Facebook and YouTube. So I really want to talk about conditional green cards and, what happens if your conditional green card is terminated and what's next. And the reason why this is on the forefront of my mind is that, starting last year, we saw something that we've really never seen, in immigration where USCIS what started to make marriage-based or children on the basis under marriage based decisions based on them submitting their file and no interviews. So it's great that they're bypassing interviews because it allows people to quickly gain some sort of status to work and freedom and ability to work. But one thing that we also noticed just from following the trends, at least in our practice, was that we were seeing a lot of cases where the approval was happening before the 2-year anniversary, or like somebody would literally be about to hit the 2-year anniversary of their marriage, and the green card would be approved maybe like a week before, or 2 weeks before, a month before. And my legal mind just begins to think, well, why is this happening, or what is it? So as I predicted, or as I saw, I started to get more consultations from people who were in that boat or in that position where their green cards were approved and they had the 2-year, but now they're having issues with their spouses, or they even had issues at that time, but they never had an interview, so this never came up. And so now it's a conundrum. Well, what are we going to do? If we get called, if we have to file for removal of conditions, and we're not able to prove that this marriage is a bona fide marriage, or that, that we deserve a waiver based on divorce, or extreme cruelty or hardship, or, the worst case, of course, is death. So I figured this was going to be a good topic to talk about. Taste D Root says, are there no interviews going on now? So I just want to make sure that you guys don't misconstrue what I'm saying. That is absolutely not what I am saying. I am saying that you have a potential when you submit an application, now for green card adjustment of status, that your interview can be bypassed. The decisions are made based on a client's immigration history, a client's immigration file, what was submitted, and an officer's preference. So it doesn't mean that everybody is going to be bypassed for an interview. It just means that we're definitely seeing a large amount of people being bypassed. So it's great, as I mentioned, to be bypassed, which also is helpful when we here try to submit strong applications so that they have a higher chance of being bypassed for the interview, just because 70% of cases that get denied usually occurs because of what happened at the interview stage. So I think it's great. The only thing is that we have to make sure that even though you got approved for your 2-year green card, that you also understand that you still have to file for removal of conditions. And the standards are just as stringent, or if not more stringent, than when you're doing the normal marriage-based case. Because at that time, you don't have the excuse of, well, I don't have my papers. I don't have a social security number. I don't have I'm not able to work. So we weren't able to get anything. So you have to really, make sure that you're documenting your marriage. To present to immigration. I know some people sometimes say it's not fair. Like, why do we have to do that? The thing is, when you're dealing with immigration, not much, you have to understand, I try to play devil's advocate from an immigration standpoint and also from an immigrant standpoint. I know that it might feel burdensome, but you have to also understand that a lot of people that are making these decisions, they don't know you. They don't know you. They don't have access to your social media. You don't text them. You're not on WhatsApp telling them about your life. So the only way they know about your life is what you've documented and what it is that you're showing them. And that's why it's really important to keep that documentation. So let's say, you got your 2-year green card. The first thing that's going to happen is you need to file for removal of conditions. What is removal of conditions? Basically, at the 2-year expiration, you can do this as early as 90 days before the expiration. You have to submit an application called an I-751, which is a removal of condition application, right, to USCIS. So you're basically asking them to remove the 2-year condition and give you a 10-year green card. So the normal requirement is that both you and your spouse sign the form and present evidence post the approval of your green card. So they don't want to see what you sent when you initially submitted your first green card application. They want to see new documents. They want to see new documents that show that you guys are doing life together, and that your marriage was a legitimate marriage, and you guys have continued to live in basically matrimony. And if you're not able to show that, there are waivers that you can submit, which supporting argument and briefs, of course, and evidence, one of which is that, we had a good faith marriage, but now we're divorced. It just didn't work out. So you have to provide proof of one, the good faith marriage, and two, of the divorce. You cannot go asking for a waiver on the basis of divorce if your divorce is not finalized. The reason why is that they will deny you, or if they request, they can also send you an RFE, which is a request for additional evidence, which is they want proof of the divorce, but you only have 87 days. So if you end up not being divorced within that timeline, you can get denied. Your second option is if your spouse passes away, you can then do the removal of conditions, and you can then provide proof of that. And remember, for your spouse passing away, for divorce, and for extreme cruelty, which I'll get into in a second, you don't have to wait till the 2-year anniversary of your green card to submit that application. You can submit it as soon as whatever you're experiencing happens, and there's also late filing that's permitted as well. Okay. The next one is, if you can show that you're married, you entered it into good faith, you planned for this marriage to work, but your spouse is extremely cruel and abusive. If that's the case, you can also submit for removal of condition based on that waiver. And then the last, and truly the least in this case, because it's really, really difficult to overcome this one, is to show extreme hardship. That's literally the only reason why, you and your spouse are not filing together. There's going to be extreme hardship for you to be deported back, etc. So they should grant you on that. And I see all your questions. Once I get through this line of thoughts, I'll try to answer some of the questions. So if you meet one of those, then you can then submit the waiver. And then if you submit, let's say you submit the waiver and or you submit a joint filing, and USCIS is like, you know what, we don't believe you. It's not compelling enough, so we're going to go ahead and deny you. What happens? USCIS now has the authority to terminate your green card. It used to be in the past where if they denied you, the only person that had the right to terminate that green card was an immigration judge, but now they can deny you and specifically write under that, and as of today, your green card is terminated, right? So if they do that, that doesn't preclude you from submitting another application. So a lot of times we want to look at it strategically to determine, are we refiling this case because we have evidence? So we've done it both ways. We've had a client that literally had absolutely no evidence. The client came to us after 2 denials of removal of conditions. Spouse brought him through consular processing from out of the country, and when he came here, he went to do his interviews, he had nothing. When I say nothing, he submitted nothing, but when he came to us, I was like, okay, we're going to dig in. We must find something, and, we started digging. We didn't have a lot, but we found some things and just tried to really understand why he didn't have anything and explain it. And I remember it was a really, really tough interview with the officer. I personally took a lot of offense on behalf of my client towards what some of what the officer said, and we let them have it, like when we were responding to the notice of intent to deny, and I told them to run that tape, because for me, one thing I know how to do is I know how to write, I know how to make a legal argument, whatever it is, and I know how to cite the laws. And we sent it and asked for only a supervisor to review this, and that client got approved. But it's hard. It's really, really hard if you don't have any evidence, because like I said, they hold you to a higher standard if you have a conditional green card. Now, we had another situation, which was one of the results that we got today, which I'm going to post later on after this live, where the person came to us basically at the time their case was just about to be denied. They had nothing. They had the interview being scheduled. So that case was denied. But then we realized that they had a child who was a U.S. citizen and over the age of 21. And, we were like, okay, this is another alternative route. So in that case, that person submitted based on parentage, and they were approved for their 10-year green card today. So that is one option. If you do get denied, is there anything else that makes you eligible? for an adjustment of status, as long as USCIS is not alleging that you have marriage fraud. Because it's one thing to say that you didn't meet the burden of proof or you don't have enough evidence to support it, but it's another thing if they're basically saying, we believe that you have a fraudulent marriage. So that's one thing. Another thing is that, USCIS may send you, this happens more often than not, to removal proceedings, which means appear in front of an immigration judge, and then you have another opportunity to plead your case at that time. And then another option is refile, but this time refile with a competent attorney, especially if, let's say, you didn't use a lawyer before, who can really study your case and, a lot of times help you with evidence that you may not even know that you had. So basically, all is not lost, until it's fully lost. So if there's always if there is a chance, I always say fight for the chance, because you might just be that 10% of, people that get your conditions removed, like this guy who on the third try, which was the first try with us, but his third try, was a charm. And that guy was in deportation proceedings, by the way. And we got that case terminated so that he could get that green card. So, it was truly a blessing, because he hadn't seen his mother in years. And it was great for him to go back, to go visit his mother. So those are some of the things that you can do. Guys, once you get that 2-year green card, you want to make sure that you're documented. I can't stress it enough. Like, people think, I'm going to get my 2-year green card and I'm good. You're not good. You need to make sure that you're documenting, because if you don't have that evidence, it's going to be much harder. Okay, let me take some questions. Any on YouTube says, good morning. I filed an I-485 based on an approved VAWA in July, and the case was transferred from Nebraska to Vermont, but I sent it to Vermont. Where will it be adjudicated, and how much time will it take, please? So a lot of cases, I think I'm not sure if you're mixing your question, because you're saying it was transferred from Nebraska to Vermont. So I'm not really sure if you're saying that you sent it to Nebraska and then it transferred to Vermont. So right now we're sending the majority of the files are being sent to Nebraska because of an overflow issue. And oftentimes you see that the cases will be transferred to Vermont, because Vermont is the one that really adjudicates valid cases. But as far as your 485, it will eventually go to your local field office of wherever you live. And those would be the people making the decision, whether to bring you in for an interview or whether to approve you. So that's where it is. From a timeline, at 485 timeline kind of takes the same time. It's different based on your field office, but, give or take, it could take anywhere from like 4 months to 13 months. So it's really a variation. All right. If you've been denied an I-485 and an I-130 before, can you travel out of the country with your new VAWA advanced parole? Well, without knowing your personal legal history with immigration, I'm not answering your question specifically, because I don't want you to travel and say, I spoke to one lawyer online, told me I could. However, if there is nothing in someone's history other than just a denial, but then they submit an adjustment of status, which is pending, and they have a travel permit, and they're not in deportation, they've not received an NOID, etc., then there's no issue with them traveling if they have a travel permit. It is very important that you take the right document with you when you're traveling. I cannot tell you, like, during this holidays, the amount of calls we got from clients who took the wrong documents with them, or had to have documents mailed over to them, or didn't know what the requirement was to travel to a specific country, where some clients, think that, if they have a travel permit, that they can go anywhere in the world. The thing is, you still have to go where your own country's passport allows you to go. So it's not based on the travel permit is just to allow you to come back into the United States. But let's say, you're from Ghana or something like that. You can't just travel to London if you need a visa to go to London, right? So you still have to get a visa to go to London, and then from London you'll be able to enter back with advanced parole. So make sure that you're doing that. Okay. Can you get remarried after you get your 2-year green card? You can get remarried, as long as you can prove that your original marriage in which you got your 2-year green card was a valid marriage. You had a good faith marriage, it just didn't work out, and your divorce is finalized. So make sure you do not remarry until you make sure that you finalize your divorce properly. I applied for my green card 11 months ago based on marriage, but I still have not received it. Is there any problem? No, that's a normal timeline, Aida. A lot of people, while some people get approved early, really 15 months ish is when I would be like, okay, what's up? What's taking you guys so long? I have a situation right now and I need help. I applied for the removal for 10 years. Now my wife put me out of the house, but I got the letter of extension. She doesn't want me to get my 10-year green card. Marvi, call me. Definitely would love to screen you to see if you're eligible for extreme cruelty. My phone number here is 407-995-6567. But I'll prefer to have a confidential conversation with you and see what's going on in your marriage. And then we can amend your application if necessary. Okay? I see, because there's so many side conversations in there, so I'm just trying to see which ones are no side conversations. How long does it take for me to get a K1 visa for my boyfriend? Dennis, it depends on where you are, where your boyfriend is, what country are they in, and also are you a U.S. citizen? Do you meet the requirements to submit a K1 petition? Have you seen your boyfriend in the last 2 years? If you meet the requirements and you submit, the first part, which is done here in USCIS, can take anywhere from 6 to 12 months. And the second part can take 6 to 12 months. I would say in the more recent times, the shortest timeline we've seen is about a total of 12 months. 7 on one end and 5 months on the other end. But that's kind of, I would say put 12 to 15 months. We're definitely seeing some movement. One good news I have for those of you from Jamaica and those of you from Nigeria who are doing consular processing, we're definitely seeing some movement where before, if you're in one of those countries, when you get documentary qualified to be scheduled for an interview in the home country, we were seeing it was taking almost 2 years waiting, but now we're seeing 7 months, 8 months, 6 months, which is amazing. So if I were you, this is a good time to consular process if that's what, if let's say something was stopping you from doing it before. And I keep reminding you guys, this is an election year. If you remember during 4 years ago, there was a travel ban where certain types of consular processing cases were no longer permitted. So, you want to get your stuff in there now so that they cannot retroactively stop those of you who are already in the process to do it if you haven't already. Okay. Yolanda says, does USCIS do interviews for removal of condition? Sometimes, not all the time. Like with every other case, a lot of it is based on discretion and a lot of it is based on what evidence is submitted. Sometimes if you have just an abundance of evidence, it's a waste of your time. And then we've seen sometimes you have an abundance of evidence and that officer chose to waste our time. And we went there with the brand new baby, even though he had all of that, because I think at the time we submitted that the baby, was she was 8 months pregnant, all the ultrasound, the baby shower pictures, all those things. But, they wanted all that. So he came with the baby and, anyway. So sometimes, yeah, you still get an interview. Okay, so let me see. Let me go back up. Is the waiver also available for divorce? If this question is for conditional green card, yes, you can submit a waiver with a brief explaining why you need that waiver based on divorce. What are the most important things we have to submit to immigration when we get married? I mean, it's long. That's literally a separate life in and of itself. But just think about it in this category. The first thing is, of course, you have to submit, if you're doing an application based on marriage, here in the United States, joint adjustment of status, the most important thing for you, the beneficiary, who's the person seeking the green card, is one, proof of entry. You have to show proof that you entered into the United States legally by some port, some legal port, whether that's land, air, or sea. You have to show that. You have to show proof that any previous marriages were dissolved properly. I can't tell you, this is the number one reason, like for clients who are Nigerian or Ghanaian, to get denied. This is the number one reason. I know you guys always get offended, like when I say it, which I really don't understand why you're getting offended, because I am giving you the tea. Listen, I'm Nigerian, so I can't offend you because I'm Nigerian, and I'm telling you, like, in order for you to increase your chances, do your divorce properly. So that you don't get denied. If you know you had a registry marriage, you know that you cannot get divorced without an attorney in Nigeria, for example. You must use an attorney. You know, if you said that your wife is the one who filed for the divorce, your suit number should not be showing HD, which means it's a husband who filed it. Like, it's that sloppy. So like things like that, you need to make sure that you have a reputable lawyer in Nigeria that is processing your divorce, because that's something really important that you should get. Other important things will be proof that you meet the income, that your U.S. citizen spouse meets the income to file for you. You know, and if they've not filed taxes, they have to show why they've not filed taxes, or they have to have a joint sponsor who is a U.S. citizen or a 10-year green card holder who meets the income requirement. And then last but not least, you have to show proof of a bona fide good faith marriage. I know this confuses a lot of people. A lot of times people say, well, here's my marriage certificate. Your marriage certificate is not proof of a good faith marriage. It's just proof that you went to court and you have a legally documented marriage. But when they're talking about good faith, they're talking about things that most normal couples will have, or most normal couples will know. You know, if let's say, you know, that list is just so long, you know, they're looking at things like bills, you know, financial entanglement. How are you guys entangled financially? Are there taxes being filed together? Do you guys have bank accounts together? Do you have credit cards, health insurance? Health insurance is actually a big one. It's much more, I would say, out of all the insurances, is the one that's the most impactful, just because health insurance is so expensive. And anything basically that requires a financial burden on your U.S. citizen spouse, you know, psychologically it makes people think, well, they're not going to put all that in there, you know, if you know, this wasn't a legitimate marriage, you know, of course, children together, you know, trips together, pictures with family members, you know, like some people send in, you know, like they want to send pictures of selfies of them like making out or kissing. Like USCIS absolutely does not care about that, because it does not show anything about your marriage. If you're going to send pictures, you want to send pictures that show a place and time, you know, of relationships. So, you know, outside of your home, you can send some in your home, but, you know, with context, right? They want to see people in your pictures. They want to see you guys taking trips. They want to see you guys going to, I don't know, like wherever you live. What are some of the tourist attractions? Like, you know, how'd you celebrate Christmas together? And then last but not the least, when you come there for an interview, you should be able to answer basic questions. If they ask you what your spouse's middle name is, you should know what your spouse's middle name is. If they ask you, what is the street to the right, or they have to cross over to make a left into your street, you should know the name of that street. What is your spouse's cell phone number? You should know your spouse's cell phone number. I know a lot of people are always like, you know, we save numbers on there now. On our phones, so we don't need to memorize. But let me tell you this, you need to, if you're applying for immigration, you need to memorize your spouse's cell phone number, the same way that they make our, you know, I don't know if you guys, you know, on here have kids, but you know that like kids in elementary or school, they teach them the parents' numbers in the case of an emergency, so that if something happens to them, they can give someone the number. But you should also start thinking about it outside of immigration as well. Like if you're in an emergency, your phone is broken, your phone is lost, you need to use someone's phone, you want to have you know, the number to remember. So like those are things that they would look at as a red flag, you know, if you don't have them. So you want to have those types of things. Oh my gosh, I'm running out of time and I have so much to say. I told you this was going to be a long question. Tin Trini says, I'll be needing an immigration lawyer soon for VAWA. I just want to know how much it will be. Call me and schedule a consultation. And then we'll see if you qualify. That'll be the first and foremost thing. And then once you do qualify, then we can tell you what we charge. How long after your American spouse gets divorced can you can you marry them and send in your paperwork? No timeline. It's really up to you. Just have proof that your marriage is legit. That's all. I'm going to be on. I know I didn't get to a lot of these questions, and I truly wish there was a way I could save them so I could just like read them through live tomorrow, but I doubt. So if you come back on tomorrow, I'm going to be on. Let me check my calendar real quick so I can tell you guys. Tomorrow is Wednesday. Gosh, I have a busy Wednesday. All right, I'm going to try and come on at 9:30 a.m. tomorrow Eastern time. 9:30 a.m. Eastern, and we can then, answer any other questions you guys have. All right, guys, love chatting with you guys as always. I hope you all have an amazing day. If you want to get started on your case, call us 407-995-6567. All right, bye.